All right, good evening, everybody. Last week we discussed euthanasia and began our discussion of the next topic, which, for want of a better term, I've used or called Jewish family values. Tonight I want to conclude our discussion of Jewish medical ethics by discussing abortion, which I deferred from 2 weeks ago, and then hopefully also to complete our discussion of the topic I'm calling Jewish family values. And then after that to go to a discussion of the topic which some of you seem anxiously awaiting, and that is the topic of loving one's neighbor. And then finally in our last session to discussion of some issues relating to social ethics. Now, I want to reiterate here something that I said at our very first meeting, and that is that there are many issues in Jewish ethics that we can discuss here, but there are also many issues, more than the ones that we can discuss, that we can't discuss simply because of limitations of time. But one of my major goals here, and I've laid out in your reading list the major goals of our deliberations here, has been not only to introduce you to certain issues in Jewish ethics, but also to introduce you to certain methodologies in Jewish ethics and certain sources that one uses in employing those methodologies. And just as we did that with relation to euthanasia in the last session and a half, I want tonight to try to do that now in relation to an issue that's been a very hot issue now for many years, and that is the issue of abortion. You have in the packet an article that I published last year in a journal on abortion, and that was published in a journal called, I think, the New Theology Review, something like this, which is a Catholic journal, so it's already strange to have an article on abortion being published on Jewish views of abortion in a Catholic journal. What's even stranger is that article was originally written for another journal, which happens to be a Catholic journal, and was published in translation in Polish in this journal in Poland, Królowa Apostolów, which means Mary, Queen of the Apostles. That's the name of the journal in Polish, on Jewish views of abortion. So it's sort of strange that this is where, means Judaism speaks about abortion. So it's sort of strange that this is where I published a few things on this of all subjects. Now, in talking about Jewish views of abortion, and I put the emphasis here on views, because, you know, you asked view, it's always views. I want to first delineate what the starting point of the discussion is not, before delineating what the starting point of the discussion is. Because the way the issue of abortion is dealt with in Jewish sources differs radically from the way abortion is dealt with, say, in American law or in social policy discussions in the United States today. The first starting point is not is that it does not start with a discussion of rights. In American law, you usually start things with a discussion of rights, and the way the abortion issue has been framed, for whatever reasons, in the United States, has been a kind of collision between those who argue there is a right to choice, coming out of a supposed right to privacy, and others argue that there is a so-called right to life. Our starting point is not that. Secondly, within the feminist movement, the starting point for discussing abortion has always been a particular right and assumption of propriety of what happens, of what one does with regard to one's own body. This is also not an assumption that you really find in Jewish sources. The assumption you find, as we discussed when we discussed euthanasia, is that the body is a kind of gift or a bailment, if you want the more legal term, from God that we steward, but not that it belongs to us, sort of a loan. And our job is to take care of it. The third thing, pardon me?
Well, that sounds pretty parallel to me. Whether you own it or whether you got to take care of it, that the feminist argument, I think, could be held along, I've got to take care of it. And
Well, you obviously don't speak to too many feminists because, you know, taking care of my body and taking care of, you know, my car, the car which is on, you know, which I lease, is two different things. The third thing the argument does not begin at is the basic premise of most modern moral theory, at least since Kant, and that is the idea of absolute moral autonomy. We do not begin with the assumption that this is a completely autonomous, subjective moral opinion as to whether to do one thing or another. Fourthly, our beginning point is not an absolute moral principle. And in this case, by absolute moral principle, you would mean that you only have two choices, and that is to be opposed to abortion in any circumstances, or on the other hand, to advocate elective abortion in any circumstances, or in all circumstances. And fifthly, finally, the approach Jewish sources take is different than the standard Catholic approach, because the standard Catholic approach, exegetically, as far as I know, beginning with St. Augustine, takes the prohibition for abortion under their understanding of the commandment of the Ten Commandments that in their translation reads, "Thou shalt not kill." In other words, the Catholic reading of the Ten Commandments is that there is a commandment that you shouldn't kill, and that includes many things, and one of the things that includes is abortion. If you look through, as far as I know, all the Jewish commentators on that commandment, they all translate it, "Thou shalt not murder," and none of them considers abortion to be murder. I don't think you'll find anywhere in any Jewish source of any period the claim that any kind of abortion is murder. So this leads us to the obvious question: if these five approaches, which are very prevalent today in our society, are not the starting point for Jewish speculation on the question of attitudes toward abortion, what has been our starting point? And I would suggest to you that the starting point in classical Jewish literature regarding abortion is in looking for precedents in how the rabbis interpreted Scripture in terms of the abortion issue. So let me refer immediately now to two texts, one in the Bible and one in the Mishnah, which is the early stratum of the Talmud, that are used by all of later sources to discuss the issue of abortion. The first of these sources, as you'll see, has absolutely nothing to do with abortion. The verse explicitly has nothing to do with abortion. So like the story of Hananiah ben Tradion that we discussed last week that didn't have anything to do with euthanasia, but is used by the interpretive process to be applied to euthanasia, here we're going to have a text that has nothing explicitly to do with abortion, but is used by all the subsequent literature to be applied to the issue of abortion. The text is a verse which you find in the book of Exodus, chapter 21. This is the chapter after the chapter of the Ten Commandments. Verses 22 and 23. And in Exodus 21, 22, and 23, that is chapter 21, verses 22 and 23, you have an episode given. And the episode is that two men are having a fight. And in the course of them fighting, there is a pregnant woman nearby. And one of them strikes, by accident, the pregnant woman, causing her to have a spontaneous abortion, causing her to abort. And according to the text, the person who struck her, the one who assaulted her, is liable for property damages, as if he injured, say, her arm or some other limb. Now, the text obviously has nothing to do with abortion. The text has to do with an issue of a fight and an issue of liability for assault. But the text is applied to the issue of abortion. And the text becomes, in the subsequent literature, a precedent for Jewish law in dealing with abortion. And what is significant here is that this text is the text used as the precedent, and not, as the Catholics do, the text in the Ten Commandments, you shall not kill or you shall not murder, in Hebrew, lo tirtzach. Now, this text is interpreted to show that since the penalty for the striker, the person who strikes her, is monetary compensation rather than the death penalty, rather than capital punishment, that therefore abortion is not a violation of the commandment not to murder, and that therefore abortion is not considered murder, but is considered something else. So the obvious question is, then what is it considered? Here it's clear that the compensation is monetary, so it's considered some kind of damage, but it's not considered murder. Now, looking to the medieval commentators, Rashi, who is of course the greatest of the medieval commentators, in talking about a fetus, uses the term the phrase lav, which in Aramaic means not, nephesh, hu. Nephesh means a person, not simply a soul, but a person. So Rashi says the fetus, the reason it is not a capital offense, in other words, the reason the guy is not guilty of murder, is because the fetus is not a human being. Who means it. It is not, or he is not a person. Now what does this mean, person? In law, you can only have an offense, say a murder, of a person. In other words, if who you kill is not a person in the law, according to the legal definition of a person, then you haven't killed anybody. So what Rashi says is the fetus is not a person in the law. The fetus has no legal status as a person. Therefore, since you can only kill a person, murder is a murder of one person of another person, and the fetus is not a person, therefore, even if you cause the abortion deliberately, not as even in this case accidentally, it is not considered an act of murder. And that you pay for the damages. Now,
Can I ask a question?
just let me finish the thought, okay? Now, if you took sort of the Catholic position, you would raise the question which is raised in Jewish sources. And that is what theologically is called the concept of ensoulment. In other words, the fetus may not be a person in the law, not have the legal status of a person, and therefore you can commit murder against such an entity. But the fetus can be ensouled. So what happens to the soul? This is one of the reasons why Catholic doctrine has been consistently against abortion. Because their idea is that because the fetus is already ensouled, therefore it's a person, and therefore it's murder. In the 19th century, even early 20th century, maybe even still today in certain places, there is a procedure used in some Catholic communities that if an abortion is indicated, say it's in a case of rape, something like this, they still feel badly about destroying this ensouled creature, especially if it's not in a state of grace, which means it hasn't been baptized. And they have developed a special device called the intrauterine syringe, where they put the holy water in this syringe and they put it in the uterus and baptize the fetus in utero, so it's therefore saved and therefore is in a state of grace, and therefore if it dies it's not, as bad if it weren't in a state of grace. But in Jewish sources you have a debate in the Tractate Sanhedrin and the Talmud as to when the child is ensouled. Is it at the time of conception? Is it at the time of birth? Is it somewhere in the middle? And what's interesting is that in the discussions in the Jewish legal sources of abortion, this issue really doesn't come up. In other words, they don't really focus on this issue. They focus on the issue of the child may have a soul, the fetus may not have a soul. It's not their issue. The issue is, does the fetus have the status of a person in the law? And if it doesn't, then killing it is not murder. Wait.
Jewish law?
In Jewish law, killing it is not murder. Now, even if it did have a soul, or even if it were a person in the law, in questions of the mother's life, where the mother's life is in danger, and I'll discuss this a little more later, but I just want to establish it here because it's related to this. Even if it were a person, I'm saying the Jewish law doesn't recognize it as a person, it recognizes it as the commentaries put it, as a limb of the mother, just like an arm or something like this. But even if it were a person, and it were threatening the life of the mother, an abortion would still not be considered murder, but would be considered self-defense, killing in self-defense. And the argument they use is an analogy from the Talmud called the idea of the rodef, which means the pursuer. And the classic case in the Talmud is like this. A is running after B to kill B. You are C. You are permitted to injure or even kill A to prevent them from killing B. And this case is then analogized to the case of the abortion problem. Because A, in this analogy, is the fetus threatening the life of B, who is the mother. And if you are C, say the physician, you are permitted, not only permitted, but required to try, you are permitted, you're not required to kill, but you're permitted to kill A in order to stop it from killing B. In other words, you're allowed to destroy the fetus in order to prevent it from destroying the mother. Okay.
So it's simple as this. Okay, there was something there when they award damages. Was the damages because of lost labor for the child or for the inconvenience to the mother? Why was damages awarded?
Well, technically damages were awarded because the assumption was that, first of all, the damages were awarded to the husband. You may not like it, I'm not so happy about it, she's certainly not happy about it, but that's the way the Bible put it. Because the husband has a proprietary relationship with the future child could work, and the husband lost value.
What is the Catholic position about the child is threatening the life of the mother?
Generally, that's the way it is.
I mean, it's okay.
What's okay?
I mean, they don't believe in aborting to save the life of the mother.
The classic position is absolutely no. You don't save. Now you have some changes going on, but I really don't see it doctrinally happening. In Jewish law, you also have another presumption that doesn't work in this case, but works in the next case that I'll mention, and that is the assumption that existing life always takes precedent over potential life. But I haven't gotten to that case yet. So you see from this argument, this line of argument, it is not posed in the question of rights. The question of the rights of the mother and the rights of the fetus or the child is not even part of the vocabulary here. Rather, the issue is framed like this. You have a spectrum of views, and on one side of the spectrum you have a case called in Hebrew chovah, which means it's obligatory. It's your obligation. So for example, in a case where the fetus is threatening the very life of the mother, for sure there is an obligation in almost every case, not in all cases. Say if the mother is terminally ill, it's another issue, but in most cases there is an obligation where the very life of the mother is threatened to terminate the pregnancy. Then on the other side of the coin, you have what is called in Hebrew, I'm giving you sort of the vocabulary of how they deal with this, in Hebrew asur, which means forbidden. In certain cases, it's forbidden to have an abortion. I'm going to get to some examples in a minute. It's not that you have the choice anytime you want. So the categories, again, of the pro-choice, pro-life are not our categories. And then in the middle, between chovah, where it's obligatory, and asur, where it's forbidden, you have a third category, which is in Hebrew reshut, which means there is a permissibility. It doesn't mean that it's required. It doesn't mean you have to have an abortion in those situations, and I'll mention some examples in a few minutes, but it means that you can find a precedent somewhere in Jewish law permitting it. So I would say that these are the categories Jewish law and ethics are working with here. Certain things are obligatory, certain things are forbidden, and certain things are permitted. What is not in this vocabulary for this specific issue are two terms that are very critical to Jewish ethics, but they don't, in my view, come to play here. And those two terms, which we've encountered before, are mitzvah, namely that it's a religious commandment, because even though Jewish law would say in certain circumstances it's even obligatory to have an abortion, nobody would say it's a mitzvah to have an abortion. And the other term we don't encounter here is midah, which is the term for moral virtue in medieval Hebrew. When we talked about humility and stuff like that, that's midah. This is not midah. So vocabulary here essentially is chovah. In what cases is an abortion obligatory? The opposite, asur. In what cases is an abortion forbidden? And then the range of reshut. In what cases is an abortion permissible? And as I think you'll see very soon, the question that Jewish authorities on law have to determine is how big of a spectrum this is. How far to go in giving permission. Now, let me get to the second text. And in this second text, you have an example of chovah, of a case where it's obligatory to have an abortion. And this is the classic abortion case in the Mishnah, the early stratum of the Talmud, in the tractate O Halot, which in English is tenths. I don't know why they put the discussion in the tractate, but I didn't edit it. Chapter 7, Mishnah number 6. And there it says, if a woman is having difficulty in childbirth so that her life is endangered, one cuts up the embryo limb by limb because her life takes precedence over its life. But if most of the fetus had already emerged, that is, if the child had been born, and this they usually interpret in the commentaries as the head has been delivered. If most of the child has already emerged, it must not be hurt, for we do not set one life aside for the other. So in other words, once the child is delivered, even if the child has birth defects or some genetic disease, you can't touch it. But until then, if the child is threatening the life of the mother, the life that exists takes precedence over the potential life. Once the potential life is actual, namely the child has been delivered, then it's another story. So this is a case of chovah. This is a case where an abortion, already in this very old text, is required. And then you come to a little later stratum of the Talmud, and then you have the Rodef case, the chaser case, in which it is also required for the same reason, because the fetus is endangering the life of the mother. The fetus is the Rodef, whether it's ensouled or not, doesn't matter. Whether it's a person in the law even or not, doesn't matter. Because even if it were an adult chasing another adult to kill them, you still have the obligation to stop A from killing B, if you can. Now, let's look at some other precedents, most of which will be in the category of reshut. But in terms of chovah, I want to refer to the opening case that I gave in this little article of mine that I gave to you. So you have to remember my problem in writing this article. The article was written for a Polish Catholic journal, published in Poland, in a country which is very Catholic and, at least technically, anti-abortion. So I had to come up with a case that they would sympathize with. And what case would they sympathize better than a case under Nazi occupation, which they also suffered? So that's why I gave this case. And this is a real case reported by the late Rabbi Ushry, who was rabbi in Lithuania and later, after the war, immigrated to the United States and was rabbi in New York and the Bronx. If you read James Michener's book, The Source, one of his responsa is in that book. The only time, I think, in all his books, Michener ever quoted a responsum. But it's not this one. It's another one. But this responsum is a case where a woman had become pregnant in the Kovno Ghetto. After she became pregnant, the Nazis made a ruling that any woman found pregnant would be immediately killed. And she goes to Oshry and says, "What do I do?" And he doesn't tell her, "Look, lady, you have a right to choice, you have a right to life," all this stuff. He says, "Look, lady, I'm in my ruling, so it's my responsibility, so you don't have to feel guilty. You have to have this abortion. You have to. Because the child is a rodef. If you carry this pregnancy further, you're going to be killed because of this fetus." So in this case, too, it was chovah. Now, in some recent responses, the question has come up, okay, these cases, okay, but what if the child is being carried by a mother who is dying of a terminal disease? Do you let her carry, even though she's going to die anyway, and the pregnancy may accelerate her death? So it's a joint abortion euthanasia question. And many of the respondents have said, here we make an exception and allow her to carry. And we had last year this case in Rochester of the woman who delivered after she died. So even though it's chovah, you always find exceptions. In other words, I'm again trying to show that Jewish law is not always absolute, that it's an absolute and relativistic morality at the same time, that you have rules, and you have rubrics, and you have structure, and you have precedents, but there is always an exception to the rule, if you can find it. Now, the question we now come to is the difficult one. And that is, not yet. First, let's go now to the other side before the difficult one. And that is, are there cases where abortion would be simply forbidden? That if a woman, for choice reasons, came to a rabbinic court and said, "I want to have an abortion," are there cases where they would always say no? They would always say no. And the response would give us some examples of this. And I'll give you some of these examples where they would forbid an abortion. They would say, you can have your choice, but that's still forbidden as far as we're concerned. One example would be, say, if a woman comes to the rabbinic court and she says, "I don't want to have stretch marks." In other words, she has cosmetic reasons for wanting to have an abortion. I would say, forget it, too late. It's forbidden for you to have an abortion just so to end a pregnancy just so you won't have stretch marks. Or if a woman comes and says, "I don't want to be fat and ugly." That doesn't work either. Second example. So the first example is the cosmetic example. The second example is if a woman, say, came and said, "I'd rather have a third car than a third child." In other words, we can't afford a third child if we have this third car, if we have this third child, so I want to abort so we don't have the third child. This is economic reasons. And economic reasons generally wouldn't hold.
What if it was economic reasons where it was the rest of the family be endangered? Say if there was only a local, what I'm saying?
I know what you're saying, but you have to hold what you're saying till we get to the area of reshut. Because the fact that this question could be even put in the area of is it permissible means it's not absolutely no, right? The third case, where you have response, you have precedents saying it's forbidden, is if the woman says, I want to have an abortion because I don't want the normal pain of childbirth. And I'm going to come back to this later, again, in the area of reshut. We're not talking here about extreme pain or unusual pain. We're talking about the normal childbirth. So it's like, lady, you should have thought of that before, type argument.
Isn't there pain in an abortion?
Not the same as childbirth. And depending on what stage of abortion, of course. And then the fourth, where we have some case law on this, is, for example, if the woman has taken an amniocentesis, and on the basis of the amnio, it shows the child's sex, and she doesn't want a child of that sex. In other words, I already have, 3 boys, I don't want another one. I want a girl. That would not be justifiable reason for an abortion. Abortion in that case would be forbidden.
Where is this coming from?
These are coming from responsa, from case law. I can give you.
That, but they couldn't do that back then. So is it just that's how they?
Well, they couldn't do it back then scientifically, but they had many folklore things of, if she carries high, it means this. If she's carrying low, it means that. So. But then again, remember, even if in these cases where they go to the rabbinic court and the rabbinic court says, no, abortion is forbidden in this case, and then they have it, it's still not murder, remember. Now we come to the difficult question. Difficult question is, I think even if you don't agree with the two extremes in the cases I gave, you can see the line of reasoning there. That there are certain cases where abortion perhaps should be obligatory, and certain cases where it should be forbidden. Now the question is, you have this vast area here of in what cases should it be permissible? In what cases fall between the permitted and between the obligatory and the forbidden. Now, we've already seen over here in the area of obligation that there are cases where abortion is required when the life of the future mother is at stake. Now, along the way, they made a jump. Conceptually, it was a big jump from this precedent that where the life of the mother is endangered, abortion is obligatory, to the position that where the health of the mother is endangered, abortion is permitted. In other words, they're using the argument of the danger to life as a precedent for a more liberal position, which is a danger to health.
When did it happen?
This is already in the Talmudic period. Then the question becomes, how far do you take that? In other words, how liberally do you interpret the meaning of health? Now let's see a few examples that you actually have in actual response in actual cases. Now, one example is, let's leave aside physical health for the minute. The question then becomes, do you expand the concept of health to include mental health? In other words, once you've said that danger to health can justify permissibility of abortion, In the case of physical health, say where a woman has a heart condition or something like this, and the pregnancy, would make her sicker, that's one thing. But here I'm talking about the question that the responsives struggle with. Physical health, it's fairly clear what it means, but do we also extend it to mental health? And they said generally we do. This is a pretty big jump. Now here's an example in one of the responsa. A woman has been raped, and the pregnancy reminds her of this trauma. So it gives her mental stress. The very fact that she's still pregnant gives her mental stress. So in this case it becomes permissible. Now, let's take a look at some of the cases that we saw before are forbidden to have an abortion. What about if those same cases cause mental stress? In other words, suppose a woman comes into a rabbinic court and she says, I want to have an abortion because if I don't, it'll cause us economic stress. In that case, you say no. But if she comes in and she says, I want to have an abortion because it's going to cause us economic stress to the point where I'm going to have a nervous breakdown, then it's a different story. Because then it's a question of mental health. It's a clear threat to her mental health. Or, for example, in the case of the one that comes in and says, I can't live with stretch marks. Suppose it's not, I don't know who, but suppose it's Cindy Crawford or somebody like this. Somebody that has their whole persona is tied up with their looks. And she says, I'll just kill myself if I see a cover on Cosmopolitan magazine or Playboy or something like this and I have stretch marks. That's another story. Because then the pregnancy is no longer a question of, elective business. Then the issue is a question of a threat to the person's mental health. So you can have the same situation, depending on how they say it, be forbidden or be allowable, permitted, depending upon the motivation. See that distinction? Okay. Now, here we have a case in 18th century Germany, which is really, in my view, mind-boggling. And, if you would tell this, say, to a Catholic or evangelical audience, they would, practically stone you on the spot. There was a very famous rabbi in Altona, that is Germany, not Pennsylvania. It was Rabbi Jacob Emden. He was a very famous rabbi. And he was very, very, very traditional. I mean, as far traditional as you can imagine. And a case was brought to him of a woman who was pregnant and who wanted to have an abortion. And he said to her, who's the father? No, he said to her, how does your husband feel about this? And she said, he doesn't know. And he said, why don't you tell her? And she said, because he's not the father. So this was a case where the woman was having an adulterous relationship with someone other than her husband and became pregnant and goes to this very, 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 very super duper ultra, right-wing rabbi in 18th century Germany, Emden, and says, I want to have an abortion. Before it becomes evident, before it shows. And he gives her permission. It's just an incredible precedent. And the reason he gives her permission is because, he argues in his responsum, the mental stress caused by the humiliation, public humiliation of carrying the pregnancy to term, given her public position, would make the fetus like the rodave and would endanger her health. So he gives permission in such a case. So my argument, therefore, is that if somebody like Emden can give permission in such a case, that the tradition is essentially very open on this subject, very liberal on this subject. Even the most right-wing authorities are very open on this subject and are willing to find permissibilities where you might not expect it. Because I would say in this case, you probably wouldn't expect it. Now let's go back to the question of physical health. So physical health in terms of if a woman, say, has a heart condition or something like this, for sure, it would be permissible. But now the question is, what if the woman has a health condition which is not life-threatening, and the pregnancy does not, make the condition worse? And let's add one other ball into the hopper, and that is if the condition she has is a genetic condition. So here's an example from one of the responsum. A woman is an epileptic. Epilepsy is treatable. It's not fatal, usually, unless you fall down, 40,000 stairs or something like this. And the woman comes to the rabbi, the court, and she says, I'm going nuts because I'm carrying this child and I'm afraid that it's going to end up being an epileptic, like me. And the woman in this responsum, the rabbi writing this responsum, says, she came to me in a state of anguish, acute anxiety, and depression, and guilt over whether the child will inherit this malady, even though she was aware that the child might not inherit the malady. Nonetheless, in this situation, he gave permission. So here it's not even a direct threat to the health of the mother, and yet permission was given. So here you have the spectrum. You have chovah, you have obligation, you have danger to life, danger to health, including mental health, and including mental health coming from public humiliation, as in the Emden case, and so forth and so on. Now, in 1949, a case came up in Canada which raised the question of whether we should move the boundary of reshut further, make it further permissible, beyond danger to life and beyond danger to health, even most liberally defined. In this case, there was a woman who was pregnant, and she already had a child, and the child was sickly, and she was nursing this child. She was afraid that the pregnancy would affect the milk of the sickly child that she was nursing, and that the child would become, as a result, more sickly. And the question she asks is, in this situation, can I abort? Do I have permission to abort? Now, here isn't the case where her life is in danger. For sure, her life isn't in danger. Her health isn't even in danger. Here is a case, and this is the issue you raised before, do we extend the precedent for a consideration of the welfare, not simply of the mother, but also of other members of the family. In this case, this sickly child that she has. And again, in a responsum written by a very traditional rabbi, originally from Czechoslovakia, who migrated after the war to Canada, he says that in this case you can. So in other words, what he has now done is to open up another jump from health of the mother, see, from life of the mother to health of the mother, to mental health of the mother, to all kinds of, possibilities of physical health to the mother. Now he opens up the new door to welfare of the family. And once you open up that new door, that new precedent, which we don't have enough time because this is only 1949 decision to judge, once you open up that new door, then the question is how far do you allow the precedent to extend? Because for sure, when they opened up the precedent to the health of the mother, they weren't thinking about, public humiliation in a case like the Emden case, and they weren't thinking about Cindy Crawford's stretch marks and things like this. So certainly when this Rabbi Oldbaum in Canada opened up the precedent to extend it to the well-being of the family, he may not have been thinking about the case of how much food they have in the house. But once the precedent is open, the issue is how far then do you expand this idea of reshut? And this, I would say, is the question of development of Jewish law. Namely, that once you set rubrics and once you set boundaries, how far do you extend those boundaries? And how precise, indeed, are those boundaries? Now, let me conclude this discussion of the abortion issue with, I would say, 4 observations, and then I'll be happy to take any questions you have. The first is that the issue of abortion, as it has been discussed in the Jewish community, say in America in the last 2 or 3 generations, has been discussed not only within a halachic or legal context, an ethical context, but also within a historical and social context. And I would say that as a result of that, you have 2 completely different positions, or 2 completely different, I would say, attitudes on this issue. One that you find amongst the sort of right-wing Orthodox, and the other which you find amongst the so-called liberal or secular Jews. The position you find amongst the Orthodox, and also amongst some others, is that even though you can adduce precedents from very respectable halakhic authorities like Emden to give permission for an abortion, in many cases, that we should not be so liberal today, but that we should instead be more strict because of the Holocaust. You find this argument in many places. In other words, that because of the Holocaust, every Jewish life, and even every potential Jewish life, is enormously sacred, and we should not so flippantly find a precedent to end a pregnancy that would bring another Jewish child into the world after a time when so many were killed. So in other words, the fact that they are letting in on the law of return now Russian Jews, many of whom by any criteria are not Jews. They're not of Jewish mothers, they haven't been converted, and it's estimated about 40% of the Russian Jews coming now into Israel, there are 600,000 Jews in Israel, so you can calculate how many people we're talking about, are being let in on the law of return. So I could say to them, look,
Why aren't they Jews?
they,
Why would they say they're Jews if they're not Jews?
because they want to get out of Russia, wouldn't you?
Oh,
I mean, some of them even buy Jewish identity papers. $500 in Moscow, you can, Louis Farrakhan could buy Jewish identity papers. So they're letting them in. All right, so if they don't want to accept converts from this country, fine. But then don't let them in, who aren't Jews at all, under the law of return. But it's not my business.
My second question is there no, in terms of talking about the status, the legal status of the fetus, in terms of being person or not person, is there no point along that line where there's no issue of trimesters or months? Or I seem to remember at some point reading about a source that said at a certain point it becomes a human, at a certain point it's no longer, there's nothing.
It becomes a human on delivery of the head, period. Abortion is not advised after the second trimester. It's another issue. But it's permitted in fewer situations than it would be, say, in the first trimester. But it's still, there would be no criminal or murder liability against a physician or somebody else performing an abortion in that case. The fact that there is no criminal liability for murder against the person performing it shows that the fetus is not considered a person. It may be even viable outside the womb at that point, but it's still not considered murder. May not be desirable, may not even be permitted, but after the fact, even if it's prohibited before the fact, after the fact, there would be no liability for murder. There might be other liabilities, but there would be no liability for murder. There's not one precedent, I think, that anyone could find in that regard. And the shift in Israel, that's, their business. For many years they were permitting autopsies for certain reasons. Now all of a sudden there's another swing to prohibit autopsies for reasons that they used to permit it. That's, the way it swings there. There was another hand here, please.
What's the difference between something that's commanded and something that's obligatory?
Something that's commanded means that it's a religious virtue to do it. Something that's obligatory means it's something you're supposed to do, but there may be no virtue attached to it. So having an abortion, there's no virtue attached to it. It's not a religious commandment. God didn't yell down, have an abortion or something like this.
Okay.
So it's an important distinction. Even though it may seem to some of you an artificial distinction, it's an important distinction. Observing the Sabbath is a religious commandment. Having an abortion isn't a religious commandment. But on the other hand, it's not, in this view, a violation of religious commandment, say, not to murder. Yeah.
I was wondering if you thought that the swing in the Orthodox and the very Orthodox position on abortion is in response to the fundamentalist Christian push against, or to prohibit legally abortions in this country. Sometimes the two of them kind of...
Right, that's why I gave the example of Israel. Right, that's why I gave the example in Israel. I didn't want to get into this country, but you're absolutely right. They're very strange bedfellows.
What did she say?
I mean, do you think that's in response to them, or that they're, that there may be some, kind of back and forth,
Let me let my cat out of the bag here, and you may find this a very bizarre view. My view is that many people in the Orthodox community, Jewish Orthodox community, are really Jewish evangelicals. In other words, if you examine them sociologically, in terms of what makes an evangelical in terms of belief pattern, not content I'm not talking about,
right.
But the same mentality, I would find very little distinction.
I can see that,
I don't want to go further than that, but I could.
Don't take now.
Well, that's why they have scissors. Yeah.
Two questions. One, if you could go back to the idea of mitzvah versus chova.
Chova.
Chova. As an obligation, then it's not a religious obligation.
Yes, it's a halachic obligation. Halakha is religious law, so there's no distinction here between religion and law.
So for chova,
Chova, in other words, if she went to the rabbinic court, the court would say, you are obliged. It's a rabbinic court. It's a religious court. There's no distinction here between the religion and the law. It's a religious law, so there's no distinction. Yes, I'm glad you have a question because we deferred this because you were away last week.
I appreciate that. You gave the example about the child with epilepsy, and I wasn't clear on whether that was because of the concern that the mother had, or whether that was because there was something seriously wrong with the child. And I wanted to know if you're aborting because there's something seriously wrong with the child.
No, in the response, the reason they justified the abortion is because they felt that the mother was so overwhelmingly depressed and guilty at the idea of transmitting to the child this disease that she had lived with, that it was harming her mental health, and that therefore the abortion was permitted. But it's interesting that at the end of the response, the rabbi writing it even says, I hope I made the right decision in this case. In other words, he was clearly affected by the woman's psychological and mental state. I mean, here's this woman, I mean, you can picture this woman sitting in front of him, yelling, screaming, crying, acting out in all this way, beating her breast and pulling out her hair and talking about how guilty she would be if the kid... this isn't, what's that movie with Mary Tyler Moore and Lake Forest? Ordinary people, where they take everything coolly. These are East European Jews you're talking about, You can picture the scene. So the rabbi says, okay, I'll give you the permission, but I'm not sure that it's right.
Is there anything else to apply to that? I mean, or would you just assume that any time the child was seriously damaged in some way that the mother would be able
I don't consider an epilepsy a serious damage, but I would say that this is a permission that's given that can be used as a precedent, but need not always be used as a precedent. For example, if a diabetic mother made the same argument, or another epileptic mother made the same argument, or, I don't know what, somebody who doesn't like having brown eyes or something like this made the argument, I would say, okay, there's a precedent, but there's no reason I have to give you permission for your case because there was a permission in another case. In other words, the responsa are case law. And case law, you have to ask the question, does the case in front of you now parallel that case in the case law? And if you say yes, then you can use it as a precedent, but you don't have to. And if you say no, then you don't need to use it as a precedent. So I want to stress again, just because you have a reshut, it means that there is a precedent for permitting something. It doesn't mean that it's always permissible.
But you don't have one that focuses on the child.
There is no child. The child isn't born yet.
No, but how about with an amnio, and they know the child would be...
If they knew the child would be an epileptic?
No,
not
anything.
even epileptic, but
As a precedent for the mother's happy, she's healthy, but the baby, the amnio shows her spina bifida.
Well, then you have the question of, if the woman comes in and she says, I don't want to have a spina bifida child, too bad. But if she says, I'm going to have a nervous breakdown, if I'm going to have a spina bifida child, then that's it. You can say you have a precedent. It all depends on what she says. I mean, she's the one that's carrying it.
And you couldn't apply anything of the arguments of euthanasia to that?
No, because there's no viable life. No. You can't even apply it after the child is born, because we had this text from Ohalot. Once it's out, that's it. You can't touch it.
Right.
Now, I for example, when this article came out, I had a long discussion about it with a friend of mine, actually is a Jew in Warsaw who has a Down child. And he attacked this article. And I said, why do you attack this article? He says, well, based on my experience with the son he has with Down syndrome, he said, I'm totally against any kind of abortion.
Well,
For
he
that
was the
reason-
father.
for
He
that
wasn't the
reason,
mother
or-
carrying the burden.
Well, the mother too. I spoke to her too.
He was
Totally.
against any kind of abortion?
Any kind of abortion.
What did he say?
He
Why
said-
was he against?
He was against any kind because he said, you think that you're against it until you actually see the child in front of you. Pardon me? I mean, and I was in their house, a little apartment there, and they're taking care of this kid all the time, and
Well, the child could have been,
and they had other children. It wasn't like it was the only child, and they had other children, and that was their position. Yeah.
well, why does he apply his case to carte blanche to everybody else? You could have there could be a situation where a fetus is non-viable. I'm not talking about, conditions that are correctable either surgically or that, the child has possibility of, a reasonable life. Even in Down syndrome nowadays, Down syndrome is not just one syndrome. There's a range of effects.
Right.
In Down syndrome. So you don't know what really
Well,
you're getting.
that's right.
When you have the situation where you have a non-viable fetus,
That's another story.
that's a...
But I mean, here you have a relation to another issue that I don't want to get into, but simply to raise, because it's a subject of very hot debate now in Jewish legal bioethics, and that is genetic screening. Now, the question came up, should all Jewish couples, after they marry, or before they marry actually, be screened for Tay-sex?
For what?
Tay-sex. So the question became, if the woman is already pregnant and they screen for Tay-sex, will there be too many abortions because they may find that, say, one of the parents is a carrier, which doesn't necessarily mean the child will have Tay-sex, but makes it a better possibility than if neither were a carrier. And many Orthodox authorities have now argued against genetic screening because it would encourage people to have abortions where if they didn't know, they wouldn't have abortions. So it's a very, I think there's something to this.
Well, don't you think there's responsibility, though, that when you have a sick child in the family unit, it does take away time spent for the other unit members of the unit? Of course, your friend would argue in Poland
He would argue.
enhances the value of the time.
He would argue that way,
Yeah.
but both he and I wouldn't call families units, I hate it when I call it my friends, I have some friends who are rabbis. And
Well,
I
let's-
say, how big are your congregation? Well, we have 1,610 units, And I said, oh, is that one of your units walking down the corridor there?
I don't understand why this woman was given permission on a flimsy thing like this man wasn't the father of her husband was.
You mean the Emden case?
Yeah.
Because he argued that the humiliation of going through the pregnancy and having somebody else's child.
No. Who knows who the father?
Well, she knew who the father was, and
The husband would know. The husband would know when she was pregnant.
well, he might know, he might not know. Eventually he'd know, but there are ways of ways of dealing with that. See, you don't read Daniel Steele novels, you'd know different ways of covering up that. But suppose, the guy who was the real father, was some 6'8" blonde, and the father was a 5'2", I don't know, dark guy. They'd know. Or if the guy was a race, they would know. So I don't know what exactly, what the problem was. I wasn't around in the 18th century as far as I know. Yeah.
When you say that there's the discussion about Tay-Sachs and the genetic engineering, is that the...
No, genetic screening.
Screening, I'm sorry. Is that the first, is that the beginning of the discussion being focused on the life of the child as opposed to the life or health or mental health of the mother? Because before you said Down syndrome, so what, or what, you know, I mean, like that just wasn't something that got considered.
No, it was more the question of the quality of life of the child. And this is an issue, it has been considered, and this is the issue really with euthanasia. Is it quantity of life or quality of life? And once you say it's quality of life, where do you draw the...
Well, you didn't give us any examples of quality of life of the child.
Because in Jewish law, quality of life is hardly ever considered.
Because that's what I'm asking. So this...
It's hardly ever
So
considered.
this part now about Tay-Sachs, if the child has Tay-Sachs, that's new to be thinking of the quality of life of the child. as part
Right,
of the
but that's not what I was reporting. What I was reporting was that, say the mother isn't even pregnant yet or doesn't even know she's pregnant, and they go in for a Tay-Sachs test, and one of them is a carrier, which ups the possibilities, but which does not mean that the child will be Tay-Sachs. The odds are totally against it if only one is a carrier, sometimes even if two, I think. But on the basis of that, say later they find out she's pregnant and they abort on that basis, even though it's not for sure by any means that the child has it. It only means that one of them is a carrier. Then the argument is that abortions would be performed that would have been unnecessary, because if they hadn't taken the screening and the child was born anyway and the child was normal without Tay-Sachs, they certainly wouldn't have aborted. Whereas in the case where one of them finds out that they're a carrier, they may decide either not to have children, or if the woman becomes pregnant, to abort, even though it doesn't follow from that the child would have it.
But are they getting permission?
There are also a lot of mistakes made in Tay-Sachs tests.
Right.
If you talk to people who've taken them.
But when they get, are they getting permission to abort because of they're concerned about the life of the child? That's my question.
This you have to ask the people. I mean, because some people would say yes, and some people would say, we're really concerned about the quality of our life after such a child is born. I can't answer what's in people's heads.
No, but so it hasn't come up as something that the rabbis are making decisions about. There's no precedent for this where the focus is on the child.
In terms of?
If you don't say I get mental anguish, but the kid has a good chance of having spinal bifida.
Say that again?
If the parent doesn't pronounce the magic formula, I will have mental stress.
Yeah.
If you worry about the kid itself.
Not the parent, the mother.
The mother.
Father,
about the kid itself.
another problem.
Question is, if the mother says...
There is no kid. That's the whole issue. Until the head is delivered, there is no kid.
So how can
That's
they
the
give
idea.
permission for them to abort with the possibility of Tay-Sachs?
You can make certain exceptions to the rules, but only for that time. And it cannot be used as a precedent for normal time. So they would say, okay, this woman in the Kovno ghetto, okay, we make, there it's chovah, but, for somebody today, even if they're suffering, say, from heart condition, it's not necessarily chovah. Yeah.
I think
Go ahead.
in one of your books or reading...
No, if you just let him finish,
But if it's a clear and present danger to the woman, most American
life.
woman's life, yes.
But the question is, will they accept it as a clear and present danger? That's the issue. What will they accept as a clear and present danger? That's the issue. Death, isn't so crisply clear all the time.
So you're saying the movement in that community is to really push the chovah into a very small...
I would say the movement is to go this way, and the movement I'm in favor of is going this way. It's very simple. In other words, my position is if you can establish a precedent based on the structure of the law and based on things that have already been, adjudicated in the past, then why, if it's moving to the left, why not? Why not? And that's exactly the same view I took on the euthanasia issue. Because it's easy to say it's forbidden. I mean, every idiot can say it's forbidden, Usually the people who say everything is forbidden, they say because they don't know the law. I forgot what movie I was watching last week, but there was a line in that movie I liked very much. It said, "If ignorance is bliss, it is foolish to be wise." Yeah.
So how do you justify your movement toward more permissibility with your stance against genetic screening and
I'm not against genetic screening. I'm in favor of genetic screening. I just said I'm sympathetic with those who argue that increased use of genetic screening may lead to increased abortions. And I think it already has. It depends what kind of genetic screening we're talking about.
If you're talking about something that you have before, you get married, like a Tay-Sachs test or something, or if you're talking about an amnio where you're checking to see if the child actually has a certain condition or doesn't or whatever, and then... It
depends what you're screening, yeah.
I'm not so sure that increase in genetic screening necessarily means that, you're going to have an increase in abortion just because there's a chance that you might
I think it's true. I don't think it's maybe. I think it's true.
I don't know. I don't see that necessarily as happening.
Well, I think it's a reasonable, let me put it this way, I think it's a reasonable concern. But then again, should you have the screening to begin with if that's a possibility that may come out of it? Especially in tests that are not always conclusive.
Well, no, but I mean, you have a, genetic screening beforehand, or, something that you have a blood test beforehand or whatever. But then when the time comes and you're actually pregnant, then, I mean, you wouldn't have an abortion based on the possibility that you may, I mean, I can't, for somebody who has a wanted pregnancy or planned pregnancy or whatever.
Well, I know cases where it's happened. Let me tell you a funny case that happened. I was sitting in my office one day, and the secretary calls, "There's a lady here to see you." I said, "I have no appointments now. Tell her to go home. Leave me alone. I have no appointments." "No, she's out here crying, just to see you." "Okay. Tell her she has 10 minutes." So they send in this lady. So the lady comes in, and she's wearing a huge crucifix. But huge, silver crucifix. Pardon me?
Color's not your union card?
No, so she's wearing and dressed, from some white ethnic suburb, I won't mention where, dressed in her best JCPenney polyester suit and pants, and she comes in and she sits down, and she starts crying. And I said, "Well, what can I do for you?" She says, and this crucifix is hanging over my desk, and she says, "I want to convert to Judaism." And I said, "You notice that thing over there you're wearing? I mean, it's sort of bizarre. You're walking around with this and you're telling me you want to convert to Judaism. Why do you want to convert to Judaism?" She says, "Well, I went for some blood tests, and by mistake they ran a Tay-Sachs test to see if I was a Tay-Sachs carrier. They put it through the wrong, thing, and it came back that I am. And I know only Jews have Tay-Sachs, and I figured it's genetically determined by God that I should be Jewish. So I want to convert to Judaism on the basis of this Tay-Sachs test." So it's not abortion on the basis of it wants to convert.
A new reach out method.
What's the ramification if the woman does go against the court, the Beth Din? Is she buried? Can she be buried in the cemetery?
Of course, of course.
Well, I thought that if you were committed suicide, you couldn't be buried.
We discussed that last week because you had that responsum of the Sami Rosh Saul Berlin where he says technically you can't because it's a violation of murdering yourself. But if you find the legal fiction, which is in this case temporary insanity, a person who is insane can't commit a crime.
All right.
Therefore, if a person killed himself, the assumption is he was insane, and therefore...
Well, what happened with this lady?
No, we must misunderstood. I said, what if the woman goes against the decision of the court?
Which woman?
The pregnant woman who's coming to get an abortion.
Uh-huh.
And they don't grant her the abortion.
Uh-huh, and she has it anyway.
No, she's going to abort. She's going against the decision of the court.
And she has an abortion.
Oh, yeah, she has the abortion.
Right, so...
What's the ramification?
There's no ramification. Look, it's the same question about the doctor who performs the abortion if the, say, court is against it. It's the same thing. There's no precedent anywhere that the person performing the abortion, allowing the abortion, is guilty of capital offense. This is totally different than, say, the Catholic view.
Well, I think she's asking, is there any sequelae to that?
They could give her...
What would they do to her? Did they find out she has...
They could do something to her if they had binding power. Say, they make her repent. She did something wrong, so they make her repent. I mean, that's it. It's not like she's going to go to hell forever. It's not like, it's a cardinal sin. It's not like anything like this. But it's not murder. In the Catholic position, it's another story. I was at a conference many years ago on bioethics. It was a Catholic conference, Jewish and Catholic bioethicists at Notre Dame. And this guy who was there, who was one of their top guys, Father James Burktel. He was then the provost of Notre Dame. Then the issue was whether he would succeed Hesburgh. I mean, really top guy. Very smart. Oxford trained. And he had just published a book, which is one of the big classic books in the American Catholic Church on abortion. It's called The Silent Holocaust. So I was sitting next to him at this dinner at Notre Dame. I was sitting there, they gave me these kosher dinners with about 7,000 pounds of tinfoil. So, he's sitting there eating this very elegant, I don't know what it was, a lobster or something there, and steak. And I'm in the middle of an excavation trying to get the little piece of brisket that gave me indigestion for 4 days out of this, tome, this tell of tinfoil. And he's sitting there dressed very elegantly. He wasn't wearing a collar, very elegantly, and with his Oxford tie, with his Oxford school colors on it and everything. And I'm sitting there talking, and I said, well, Jim, don't you think this was a rather inappropriate title to have a book on abortion invoke the memory of the Holocaust? Don't you think that this is an affront to the victims? I still hadn't opened the thing yet, but... And he gave me an answer. There was no comeback. There was no comeback to his answer. His answer was, my grandfather was Jewish and he died in Auschwitz. No comeback to that. I couldn't say the same thing. So I had no comeback to this. Yes, sir.
I thought we determined that if economic hardship caused mental stress, that abortion was...
Depends on the level of mental stress.
Huh?
This is, again, the problem. Once you open up the category, how far do you take the category? So if you open up mental stress, how far are you going to take it?
Okay, but we had said that there's been precedents where a woman who was going to cause economic problems for, and that kind of stress, and mental stress, psychological stress.
This isn't simply mental stress. This is like to bring you to the verge of a nervous breakdown.
Okay. In India right now, they're having a problem
I mean, you could justify not paying your taxes because it might, bring you mental
Well,
stress.
you can't justify it. You have to not pay your taxes, and then they'll collect it anyway. But anyway, India, they're having the problem now where they're going and predetermining the sex of a child. If it's a female child, they're aborting to the point where they're not even allow pre-screening. Okay.
Mm-hmm.
And they're doing it because of economic reasons, because of the
Well, in the past they used to kill the child, so
Yeah,
it's
they
a
used to
little
do it.
better. It's a big advance.
Would you say that is ethical or moral?
In their case, probably it is, because if you have people starving, you want to limit the population. The people who are already alive, if they would starve to death,
just the female child.
you have to make a determination, in my view, based on the result, not on the basis of the criteria. The result is that the more children that are born in that society, the more people who are already existing will starve. I mean, I could argue both sides of the case.
Yeah, I know. And both are legal. It's like according to your book anyway, that, if the Orthodox do not accept the ruling, they can accept their own ruling and reject yours, and custom plays a role in it. So you can have, and it's been traditional through history.
Now, here there's no issue of custom. Here there's no issue of custom.
Well, no,
I didn't quote any
but
custom, sir.
it could still be rejected.
Sure it can be
And
rejected.
it's through the tradition, through the history, there has been more than one.
That's the way I began the discussion, Jewish views of abortion. Now let me add one other thing, then we'll take a break, which sort of is the party pooper line. Some of you have heard maybe of the idea in the Talmud and the Tractate Sanhedrin, 7th chapter, about what's called the 7 commandments to the sons of Noah. These are considered the 7 commandments which are the basis for minimally civilized society, which are obligatory on non-Jews. In other words, it's Jewish law, but obligatory on non-Jews. In the rabbi's interpretation of the 7 commandments to the sons of Noah, the commandment not to murder is interpreted to include abortion. And I gave a presentation once to a group of Catholic priests here in Chicago about Jewish views of abortion. They invited me to talk about this, and I went through this whole thing with them about how, look at us, great, Jews are so liberal, and all my rabbi colleagues there were all so happy, look at how liberal we are over these, backward Catholics. And then I said, but that's the law for us. That's our law for us. But our law for you is that you're right. I said, no. Totally different. No, Sinaitic covenant and the Noahide covenant, 2 different things.
And on what basis do they interpret it to include abortion?
That's the way they interpret it. Look, that's just the way they did it. All right, 2 more questions, then we'll take a break, please.
Is that Talmudic or?
Is what Talmudic?
The seventh law, the 7 laws of Noah.
Yes, it's in the Talmud Sanhedrin, chapter 7. Whole discussion in the Middle Ages on it, tremendous literature on it. I was once in Dallas. I was many times in Dallas, but I was once in Dallas conducting high holiday services. And I come back to this little hotel. It was about 3 miles down a dirt road to the synagogue. I was walking there, and these guys were driving with shotguns, They didn't particularly like Jews, and I'm walking there, coming back from the services after Yom Kippur, and I'm very hungry, and I get into the hotel room finally, and all I want to do is eat something and collapse, and the phone rings. And this guy gets on the phone, with a thick Texas accent. And he says, "We're in the lobby. We have to see you. We're sent by so-and-so." God. I said, "Can you meet me instead in the restaurant?" Fine. We meet him in the restaurant. And his question is, about whether the people who keep the Noahide covenant males have to be circumcised. I haven't eaten all day. I'm dead tired. I'm chased down the road by these guys with shotguns, yelling anti-Semitic epithets at me. And this guy, I'm sitting there eating for the first time in 27 hours, and the guy's asking me about whether he should be circumcised. Not my business. And then I find out later that they're part of this movement, and there's, I think, 20,000 of them in the United States who call themselves the sons of Noah, the Noahide covenant. They're evangelical Christians who consider themselves obeying the Noahide covenant. And some are circumcised, some aren't circumcised. Not my business. I was amazed to find out there are so many of these. Okay, on that happy note, we'll take a little break.
I want to know what happened, what you told the lady.
What lady?
The lady with the big crucifix.
Oh, I told her not to convert.